Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources. Welcome to today's edition of Helping Seniors Television from the Helping Seniors Network. Whether you are caring for a senior, are a senior, or just plan to be one, we hope you'll enjoy today's program. Board-certified Florida elder law attorney Bill Johnson and Helping Seniors TV host and senior advocate Joe Steckler visit together on this episode of Helping Seniors TV as they discuss the topic, Things to Know About Elder Law.
Bill, we were talking in the past about some of the different technologies that are starting to affect the legal profession, especially in the area of senior care. Would you have to just talk about that a little bit today?
Okay. As you know, a lot more things are going online, and we're having more and more accessibility for people to go on and look at different legal-oriented things. There are now a proliferation of websites where you can go online, pay a fee, enter some data, and it will print for you a will, a trust, those kinds of things, or maybe it'll incorporate you and print out some articles of incorporation or for a limited liability company. Also, the ability to go online also allows people to use search engines like Google, whereby you can go online, type in a search, and you can do your own research. You can find out different things about how estate planning might work, or you can find out how to incorporate, or things like that.
Okay.
So that's available online as well. And there are also now available forms that you can even get from the Florida Bar, namely one of them. And you can get these forms and you can actually fill in the blanks and do your own litigation, you know, like your own divorce, a do-it-yourself divorce. And they have forms printed and instruction sheets on how somebody can go through and fill these things out and then file their own divorce and come up with their own settlement agreement and you know, work through the process of doing a dissolution or an eviction or something like that. So the online access, and increasingly seniors are online, they have the ability to find these you know, forms or companies that will complete these forms that will generate documents, whether it be for incorporating or estate planning or even litigation, as well as going through and researching different legal issues. And you can, as many issues as you can think of, you know, you can type in, and if you want to know something about constitutional law, you type it in, your question, and you can find a variety of sites and even white papers on these subjects. So the landscape is changing, and increasingly I'm finding clients coming in with increased knowledge in certain subject areas. You know, they come in and they said, well, I've gone online and I know a little bit about this, and, you know, here's what I think I know.
But I think that could be good for you.
That could be good for you.
But it can also be bad.
It can be very bad for them.
How could it really be bad for them?
Well, a little knowledge is a dangerous thing. And if you go on the internet, it never tells you the complete story.
Okay.
So for example, I have a variety of clients who use an online document assembly program with a company. And you pay a fee, you put in your data on how you want your will to be, and how you want your power of attorney, and how you want your healthcare surrogate. It will create the form, then you print it out on your printer. But when it comes time to execute this form, guess what? There's some instructions there, but I find a lot of people, maybe even as high as 50%, don't follow the instructions. You know, when you execute a will, you're supposed to sign it in the presence of two witnesses who are all in the presence of each other and attest that they each saw each other sign. But I get people to come in with wills or powers of attorney where they've signed it, no witnesses, or they signed it on a Tuesday and then somebody else dropped by and signed it on a Wednesday, and you can't tell whether or not these people actually saw the testator sign it, but they don't execute the documents properly. And if the document isn't executed properly, it's invalid.
Invalid. Do wills have to be notarized?
Well, if you want a self-proof of a will, which is where a notary witnesses the testator and the witnesses sign, and then signs an affidavit, that has to be notarized. The notary notarizes that. But does a will have to have a notarization? No. It has to be signed in the presence of two witnesses, and those people have to witness you sign it and each other sign it, and then attest to that.
Even, you know, just on the numerous radio and television shows that you and I have done together over the years, a lot of the things that we talk about keep sticking with me. And one of the biggest things would have to do with when you talked about doing a will. If you did a durable power of attorney and you did this thing from an online kit, you may not get everything in there that you need to have in there.
Well, one is you're relying on somebody else's document, and it may or may not be a good document. Two is I would venture to say, if you're going online and doing this, you don't know whether the law has changed or not changed. So you can't really tell whether you are getting the latest up-to-date document that deals with the latest legal changes. So, for example, in Florida, we had a law change in 2011 about durable powers of attorney. Well, what we found was a lot of these places that deal in these documents, whether they're selling them online or in paper form, never changed their documents. And subsequently, even for a year or two after the law changed, their documents didn't comply with the new law. So you may think you have signed a document and it says durable power of attorney on it and that you're all covered, and then when you go to use it, you find out that you're not because it didn't comply with the new law. So not only do you have to make sure that you execute these things properly, but you also have to make sure these are the latest, greatest versions and they have all the language that you're going to need in them.
You know, a lot of people, when I think about the topic you and I are discussing today, that, you know, it's really important to know all this. Now, this is somebody saying this. It's really important to know all this if you've got a big estate, you got a lot of money, you got a mansion you're going to leave somebody, a lot of acreage or things like that. But for the average Joe Doe, it doesn't make any difference. But to the average Joe Doe may have some little bitty thing that means an awful lot to them that they want to get to the right person. And if you don't have the right kind of will, or if you have a document that doesn't specifically state what you want it to do, then your wishes are not going to be carried out.
Correct. Let's say you were doing a will and you wanted to leave everything to one of your kids. You have multiple kids, and then you mess up the execution of the will so that when you die, everything gets divided 3 ways. Well, your wishes weren't followed, and you've made a pretty substantial deviation of what your intention was. And there are some things, just so you know, that aren't in the statutes. You know, when we started the conversation, we were talking about, you know, legal research online.
Okay.
And how you can just simply, you know, the Florida Senate has a very good web page that shows the Florida statutes. And you can go there, you can look up wills, trusts, estates, and look at the probate statute, and you can come away thinking you know everything there is to know about wills. But you don't, because we have a common law legal system. So those statutes are interpreted by case law. And unless you've gone and researched the case law, you would not know that there may be some problems. For example, let's say I was going to do a do-it-yourself will, and my daughter had moved down from New York to take care of me. So I wanted to do a will, leaving everything to her, and say I had 2 or 3 children. Well, she comes down to visit, we sit in front of the computer, prepare a will that says I leave everything to her when I die, I sign it, we get the neighbors to come over, they witness me signing it, and everybody's all there, and I give her a copy of the will right after it's signed. Well, that sounds all fine and dandy, and that would be legal, except I may have just done a textbook case of undue influence. And unless you know, there's a case called the Carpenter case, which spells out what undue influence is, whether somebody assists in the preparation of the will, knows the contents, is present when it's executed, all those things, you wouldn't know that. So I die, and I think my estate's going to go to this daughter who helped me out. Well, my other 2 kids contested on the basis of undue influence, and all of a sudden my will gets thrown out. So unless you know something about undue influence, or even better yet, let's talk about capacity. When does somebody have capacity to do a will? And is a child qualified to even make that determination?
Okay.
And if nobody else is in the room and they're just going on an online computer to do these documents, who's judging whether the testator has the capacity to do that?
You brought up something when you first started and talked about several children. There's so many large families, extended families. Let's say, just hypothetically, let's say there were 4 children, and maybe one of the children may have been estranged from the family for a number of years. Mm-hmm. And is there anything that could, if a family has had no contact at all, yet, and they have a will, is it safer to put that person in the will?
You have to name them so it doesn't look like you forgot one of your kids. But you can say, I leave nothing to so-and-so.
So should a person do something like that?
Well, let's talk about that. Okay. Remember, I was talking about what is capacity. Well, if you've been around wills, you know the capacity to do a will is that the testator must know what their estate consists of,
right,
who their heirs are, the objects of their bounty, as they say, and how they want to leave their estate to those people. So if you prepare a will and you forget to mention one of your kids, well, you didn't list the objects of your bounty, which could get the whole will thrown out.
So there is a danger in not naming all of the children in the will.
Correct.
See,
because it looks like you forgot who your kids are.
So that gives then a real mean attorney a possible way to get the will tossed out.
Yeah, and filters right into that discussion. We were talking about capacity. So whether or not somebody has capacity. To talk about this in another context, let's talk about incorporating. Say I went online and I incorporated a company. They filed it with the Department of State, and I get the corporation back, and we apply for a tax ID number, and I'm up and running. I can go to the bank and take that incorporation paperwork, the tax ID number, and open a checking account. Well, what don't I know about? Well, I don't know about having to have corporate meetings every year. I don't know that if I pay myself, I may have to pay payroll taxes and withholding and Social Security and all those other things. Okay. I probably should be talking to an accountant, get everything set up right. I probably should have some accounting software and get everything organized. But just incorporating, that's only one little facet of starting a business.
Oh, I know that. But are you saying that somebody would go out and incorporate themselves in a business and
not do any of that? Yes.
I can't believe that.
I have lots of people like that. All they've done is file the paperwork with the Department of State, got a tax ID number, and they don't know anything about the rest of it.
Well, even as a nonprofit organization, I know that you have to do all these other things. I mean, of course, I've set
Right.
2 or 3 of them up. So, but I even, when I did this, I had an attorney do it.
Correct.
That is, I can't pay him.
But that's why you know you have to do these things and have meetings and file reports. Lots of people don't know that. Lots of people go online, incorporate, and that's their last act with regard to their corporation.
We're talking about here, do-it-yourself things that affect everybody. But how
Right.
about do-it-yourself things
Now-
that affect seniors?
Now, we haven't gotten on to the third
Right.
do-it-yourself thing, which is do-it-yourself litigation.
Okay, let's talk about that.
And, you know, we make it easier, at least the Florida bar has tried to make it easier for people who can't afford an attorney to do it on their own. And one of the primary areas they've really tried to help people out is in the area of family law. And there are a whole slew of forms that allow you to do a lot of these things by yourself, especially if you don't have children or a huge estate, you know,
Very
that you're
simple
going to have to
things.
argue about. But a lot of people try to do everything themselves in a very contentious dissolution of marriage setting or a very contentious child custody setting. And I can tell you, having done that in the past, I used to be in a past career family law attorney, that when somebody represented themselves, they were fair game, you know, for the opposing side to go right after them because they did not typically know what they were doing. If we were in a hearing, they didn't know the rules of evidence, so they had a really hard time trying to get their evidence in. And if it was something that was really contentious, they, you know, went in there at their own peril. And a lot of people lost a lot of times when they try to represent themselves in those situations. So there's a fine line between here, fill out a form and do something routine, or here, you really need to go get counsel because this is much more complex. And sometimes people don't know where that line falls.
Well, I mean, you've opened up a whole bunch of questions to me because you watch television shows and you watch things happen in real life. You read these things in the newspaper and you say, well, why didn't they just do this? The reason some of these things haven't been done is because the way the thing was presented makes it illegal for the judge to admit it
Correct.
as easily as somebody wants to.
There are
you
rules
have
of
to know
evidence.
the law.
Yes, there are rules that govern what gets admitted in court, what does not get admitted in court. A great example of this is the last topic I was talking about, which is legal research. You do a trial, and then the judge at the end usually asks if you have any case law to bolster your position. Because when you do a trial, you're arguing about the facts of the case.
Right.
And then at the end, usually you do a closing, which is your legal argument, and you supply the court with some case law that says, hey, this is how judges in the past have ruled given these facts. So if you find XYZ, here's the way you should rule. A lot of times I represent clients, God bless them, and we get to that point where we're talking about submitting the case law. What kind of case law? And they present me with all these cases they found online. And I start reading these, and they're all from Iowa. Okay,
Doesn't apply in
Iowa
Florida.
case law does not apply in a Florida state.
Right.
And,
Even I know that.
And even Florida state case law may be from a circuit that has a different ruling.
Within Florida.
Yeah, so you can't use necessarily a second district court of appeal ruling in Florida in the 5th District Court of Appeals, unless they've ruled the same way, or unless the Supreme Court has laid down So the Supreme Court will trump the district courts trump the circuit courts, and the circuit courts trump the state courts.
You know, you have just really, you've sort of obliterated most people use of these standardized documents, honestly, because
I still get people who come in, Joe, with a one-page power of attorney where it says, I hereby grant all the power I would have to my attorney in fact, so-and-so, and they sign it, and two witnesses and a notary. And that hasn't worked in Florida since 1995, okay? Because in 1995, they changed the statute and said, you can't do a broad grant of authority like that. You specifically have to give somebody the authority for each and every act that they can do. So a document like that hasn't worked in Florida in 20 years, and I still get them hot off the presses in my office.
A lot of people think that if I write something on a piece of paper and sign my name to it, I have bound the person reading the document to do as I've specified. And
that's not necessarily true.
That's not necessarily true.
And a good example of that is you go online, you do this will, you follow all the instructions, you do everything right, and let's say it's perfect. You got it right. And then 3 years later, you decide you want to change it. And what do? You scratch out somebody's name and initial next to it.
Right.
That doesn't work. But you wouldn't know that unless you had talked to a lawyer who told you you can't amend a will by simply blacking out a name and initialing.
How do you amend it?
Well, you have to follow the same procedures that you do for the execution of the will. Sign it in the presence of two witnesses and each other's presence.
So you have to make a whole new will and get it done. You just
Well,
can't amend it.
You could do something called a codicil, which is an amendment to a will.
That's an amendment.
Generally speaking, with a will, we would do a whole new will.
Well, let's, we didn't have this written down anyplace to talk about today, but let's talk about this just for a second. Revocable and irrevocable.
Mm-hmm.
What does that really mean?
Well, one means you can amend it and the other means you can't. So if you have a revocable trust during your lifetime, you can change any of the terms, including doing away with the whole trust. Irrevocable means when you create it, you do not retain the right to amend it or change it.
Why would you do that?
Because you would do that for either a tax purpose or some sort of planning purpose, if you wanted to move assets out of your estate. So generally speaking, something's includable in your estate if you either have the control or the benefit of it. But if you put in an irrevocable trust with a different trustee and you don't retain the right of control over those assets or the benefit, you may move it out of your estate. So there are reasons people do it for estate tax reasons, sometimes income tax reasons, sometimes, Medicaid planning reasons.
You've scared me.
I scared you.
You scared me because, folks, I already know that I've got to do some work on my trust, but I cannot honestly remember whether mine is a revocable or irrevocable.
It should be a revocable trust.
If
it was done for estate planning, and you don't have a huge estate, 9 times out of 10, it's going to be a revocable trust.
Where does it say it, on the front of it?
It should say it on the front of it, and then there should be a clause talked about rights reserved to the grantor, whether the grantor reserves the right to amend or revoke it.
You've scared me enough that I'm going to look at that when I go home tonight from after the show today, after work. But
that's one other thing I when you do these things online, there's never a chance to sit down with somebody and talk about how does this work, how does this interact, what powers do they or do they not have. Again, you're dealing in a very impersonal kind of situation where you can't get some of those questions like you just asked me answered.
Right.
Now, a lot of people don't know, but in Florida, we just had a bill that came up about executing documents electronically, where you wouldn't even have a paper document. The document would simply be stored in a digital form, and everybody would execute it via Skype. So
I wouldn't do that.
well, you know, that's somebody's business model, and that may be what's coming down the pike in the future.
I can't imagine doing something as important as a will or a power of attorney and not having a paper trail.
Yeah. Well, right now in Florida, you can electronically sign a deed. So it's already here. So
You can do it, but you don't have to do it.
you do not have to do it.
You can make a choice. There was something else I wanted to ask you. Let's say we got almost out of time, but if a person has an irrevocable trust and one of the partners dies, then the surviving spouse cannot change anything, right?
It depends on the trust. If you have a joint trust, it will say whether or not it takes two people's signatures to change it or just one of the grantors.
Again, a good reason for whatever you're doing to go to a reputable attorney, have them look at the paperwork, see what you want, what your intentions are, and then do the paperwork so that your intentions are met legally.
You know, to save a few bucks, sometimes you can create huge problems.
Hey,
And sometimes spending a little money is a little better than having a huge problem.
yeah, a will's about $200, right?
Yeah,
Okay.
somewhere around there.
We're out of time, Bill. I want to thank you.
Okay.
It was a great show today.
Well,
I
thanks.
learned.
Okay,
Thank you.
good.
And thank you, viewers, for watching today's show. I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.